Thank you to all the panelists for your valuable insights. Now we will have another special talk titled Effective Conflict Resolution with a focus on Cyprus civil procedure rules and mediation as a pre-litigation measure. Please join me in welcoming Despo Andreou and Nota Pelekanou, directors at Pyrgou Vakis Law Firm, Cyprus, for this essential discussion. The presentation.
Good afternoon, and thank you for remaining in your seats instead of going out and enjoy Dubai. We had prepared a detailed presentation, but due to the delay, and we assume that you are all tired and you want to leave, we decided to address to you a brief and a short speech instead. My name is Despo Andreou, and I am one of the founding partners of Pyrgou Vakis LLC, a legal law company in Cyprus, and together with my colleague and co-partner, Nota Pelekanou, we are honored to represent our law firm and to contribute to this distinguished forum. Today, we will explore effective conflict resolution, insights from Cyprus civil procedure rules, and mediation as a pre-litigation measure. In an ever-evolving global landscape, conflict resolution is more critical than ever. Businesses, particularly those operating internationally, need efficient mechanisms to resolve disputes. Cyprus, with its strategic geographical position, stable legal framework, and modernized procedural tools, offers unique opportunities in this space. Where is Cyprus? For those who don't know, Cyprus is located in the Eastern Mediterranean at the crossroads of Europe, Asia, and Africa, and holds a strategic position connecting these regions. Cyprus is a member of the European Union since 2004 and follows EU laws and regulations while maintaining a legal system rooted in English common law due to its colonial history. This blend of EU directives and common law principles creates a modern and official legal framework. Okay. Why is this topic important? Cyprus has become increasingly attractive to multinational corporations for several reasons. Favorable tax regime. Cyprus has one of the lowest corporate tax rates in the EU, paired with a beneficial no-dom regime. Strategic location. Cyprus is situated at the crossroads of Europe, the Middle East, and Africa. Supportive environment. Cyprus has a legal system rooted in English common law, streamlined registration procedures, and government policies fostering business growth. Quality of life. Cyprus offers an educated workforce, a pleasant Mediterranean climate, and a welcoming culture. Third country working permits. Companies from non-EU countries can set up easily in Cyprus and employ third country nationals with attractive benefits. These factors, along with the ability for non-EU companies to set up operation easily, underscore the importance of a robust conflict resolution framework. The current landscape, traditionally, litigation has been the primary avenue for resolving disputes in Cyprus. However, this approach can be costly and time-consuming. Recognizing this, the government introduced mediation through the Mediation in Civil Disputes Law, aligning Cyprus legislation with the EU Mediation Directive. Additionally, the existence of a law on mediating family disputes is showcasing a strong commitment to apply mediation in sensitive areas such as family law. In recent years, Cyprus has adopted significant reforms to enhance its dispute resolution capabilities. New civil procedure rules. Effective September 1st, 2023, these rules aim to promote efficiency, speed, and cost-effectiveness in judicial processes. Key innovations include mandatory pre-action protocols and a streamlined fast-track procedure for claims up to €10,000. The fast-track approach ensures quicker resolutions for small claims, making justice more accessible. Alternative dispute resolution. For the first time, the civil procedure rules explicitly define ADR, which encompasses negotiation, mediation, and arbitration. Courts are now empowered to actively manage cases and encourage ADR when deemed appropriate. Active case management. The courts now encourage and facilitate ADR processes, emphasizing the role of judges in steering cases toward resolution outside traditional litigation. And now my colleague Nota will continue.
Hello, everyone. Now I will refer to the new civil procedure rules. I will try to be short and brief because I understand that you are all tired. As was already mentioned, the rules were effective from September 1st in 2023 and is governing all cases filed on or after this date. The objective of the rules is to ensure that cases are handled fairly while promoting efficiency, speed, and cost-effectiveness in the judicial process. A significant innovation of the rules is the introduction of pre-action protocols, which are now mandatory and designed to streamline case preparation and resolution. Those protocols encourage mediation before proceeding to court and outline the steps parties must take before filing a claim. Failure to follow these steps without a valid reason may result in penalties. Anyone filing a court claim must follow the applicable protocol. And since the rules are still recent, no judgments were already issued regarding alternative dispute resolution. However, based on our experience, the adoption of the pre-action protocols has significantly helped in resolving many cases before they reach court. A fast-track procedure is introduced in cases involving amounts up to €10,000 and now are handled swiftly and efficiently. Most importantly, the benefits of the new rules enable parties to choose Cyprus law as law of the contracts, since the new rules will facilitate resolution of disputes. The meaning of alternative dispute resolution is for the first time included within the context of the civil procedure rules. Before 2023, ADR was not included in any procedural rules. According to the interpretative provisions of the rules, alternative dispute resolution means, and I'm referring to the wording of the rules, the procedure for settling disputes, including negotiation, mediation, or arbitration, without recourse to the court. Another innovation is the introduction of the active management of cases by the court. Active management includes encouraging the parties to use an alternative dispute resolution process if the court deems it appropriate and facilitating the use of such process. The court has now the power to encourage parties to use ADR methods even after proceedings at court have been initiated. Even Cyprus High Court encouraged mediation. A judgment of 2016 was referred to the matter. The High Court specifically referred to the benefits of ADR of ADR. More precisely, the court in its judgment stated, "We are saddened by the fact that a dispute that began 13 years ago, in 2002 actually, with the lawsuit filed 11 years ago, must now be referred for retrial. Of course, the responsibility for this development lies with both the parties involved and their lawyers, who over a very small amount of money failed to reach an amicable settlement or refer the dispute to arbitration or another form of alternative dispute resolution. As a result, the legal expenses incurred to date have far exceeded the amount of the original dispute. We hope that even at this stage, the parties, with the assistance of their lawyers, will come to their senses to avoid further proceedings." The above judgment is the only judgment we managed to find referring to ADR and shows High Court's urge to such methods. Mediation as a game changer. A particularly transformative step is the increasing integration of mediation into Cyprus legal culture. On January 2025, the Cyprus Council of Ministers approved a bill mandating mediation before filing lawsuits for commercial disputes up to €10,000. This aligns with the government's objective of reducing court backlogs and legal expenses. The Cyprus Bar Association supports mandatory mediation and is now actively involved in refining this bill to ensure its effectiveness. Mediation is steadily becoming a cornerstone of our justice system, offering cost and time efficiency. It is significantly less expensive and faster than traditional court procedures. Amicable resolutions, mediation fosters friendly settlements, preserving relationships. Confidentiality, the private nature of proceedings, protects the reputation of parties involved. Beyond the most common areas of mediation, such as civil and business disputes, mediation has proven particularly effective in family law, resolving disputes related to child custody, alimony, and property division, employment disputes and HR mediation, addressing issues such as an unfair dismissal claim, workplace harassment, wage disputes, and bullying, providing a collaborative solution. Small claims, offering practical solutions for low-value disputes without incurring high legal costs, ensuring quicker resolutions. Labor cross-border disputes. Mediation has also been integrated to handle labor disputes effectively, supported by EU frameworks and Cyprus mediation law. The benefits of mediation. Mediation provides distinct advantages: efficiency, faster resolutions compared to court processes; privacy, proceedings are confidential, protecting reputations; cost savings, lower legal fees and associated expenses; collaborative solution, parties can achieve harmonious, long-lasting outcomes. Many steps can be taken to help mediation become a more popular and widely used tool for alternative dispute resolution. The first step is to raise awareness. Many people are unaware that mediation exists as an alternative way to resolve disputes. People should be educated about mediation and informed about its benefits. By doing so, a mediation culture can be established, substituting the litigation culture, where mediation is seen not just a legal requirement, but as a valuable approach to conflict resolution. As lawyers, we have a responsibility to promote mediation. First, we must familiarize ourselves with the process and its advantages, and then educate our clients about its benefit, helping them understand how it can be an effective way to resolve disputes. I believe offering in benefits for using mediation will be very helpful, as it provides people with another important reason to choose mediation, especially since money and cost are concerns that matter to everyone. In conclusion, connecting data on mediation outcomes and seeking feedback from participants will support continuous improvement of the process and demonstrate its effectiveness.
Why Cyprus is an ideal center for arbitration and mediation. Cyprus offers several advantages that make it a preferred choice for international dispute resolution. Location. Its geographical position makes it easily accessible to parties from Europe, Asia, and Africa. Legal framework. Cyprus adheres to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958 and other international conventions ensuring global enforceability of arbitral awards. National laws, including the arbitration law, provide strong framework for resolving disputes efficiently. Also, Cyprus, as a European Union member, enjoys harmonized regulations and access to the European market, enhancing confidence in the reliability and enforceability of dispute resolution processes. Expertise and professionalism. Cyprus boasts skilled mediators, arbitrators, and legal professionals who are multilingual and experienced in cross-border disputes. Cost effectiveness. High-quality services are available at a much lower cost compared to other dispute resolution centers. Mediation-friendly environment supported by EU directives and national laws, Cyprus has integrated mediation as a viable option for civil, business, commercial, and labor disputes. Cyprus has integrated mediation as a dispute resolution mechanism supported by the EU Mediation Directive and the Cyprus Mediation Law. In conclusion, Cyprus' legal advancements and its emphasis on mediation and alternative dispute resolution position it is as a model for effective conflict resolution. By embracing these tools, we not only streamline justice, but also foster a culture of collaboration and efficiency. Cyprus' commitment to modernize its legal system, combined with its strategic location as skilled professionals, makes it an ideal hub for conflict resolution. Whether you are a legal professional, a business executive, or an advocate for fair and efficient justice, these developments hold promise for all. Thank you for your attention. And I hope that we didn't take you long.
So do we have any question from the audience side? All right.
Thank you.
Thank you. I will now request Anshul to please share the mementos.
Thank you.
Thank you again.
That's your side.